For informational purposes only, not legal advice. Automated contracting is no longer unusual. The hard legal question is not whether automation exists, but whether the law can recognize system outputs, attribute them to a person, and preserve transactional certainty. MLAC was adopted by UNCITRAL on July 11, 2024, and then approved by the General Assembly on December 4, 2024. It sits on top of earlier UNCITRAL electronic commerce instruments, especially the Model Law on Electronic Commerce and the Electronic Communications Convention. It supplements those instruments rather than replacing them. That supplemental character matters. MLAC is not trying to rewrite general contract law. It is aimed at the narrower problem of legal uncertainty when contracts are formed or performed through automated systems. MLAC rests on three familiar principles: non-discrimination, technology neutrality, and party autonomy. The text deliberately avoids privileging terms like AI or smart contract. It prefers a broader and more neutral category, the automated system. MLAC defines an automated system as a computer system that can perform actions without necessary human review or intervention. That definition is broad enough to cover both deterministic and non-deterministic systems. Just as importantly, MLAC does not force automated contracting into a simplistic functional equivalence model. It recognizes that these transactions may not map neatly onto older paper-based categories. Articles 5 and 6 do the foundational recognition work. Article 5 says a contract cannot be denied legal effect solely because an automated system was used. Article 6 recognizes that contractual terms may exist in code, and that dynamic information such as price or location data may drive contractual operation. Article 7 is the doctrinal center of the model law. Attribution here does not mean giving legal personality to the machine. It means identifying the person behind the system output, so the law can treat the act as legally connected to someone other than the system itself. The structure of Article 7 is straightforward. If the parties have agreed on an attribution rule, that agreement comes first. If they have not, the act is attributed to the person who uses the system for that purpose. The official commentary treats this as an objective inquiry. That fallback rule is not a guess about subjective intention. The commentary points to objective connecting factors such as deployment, control, benefit, contractual purpose, and trade usage. In other words, the law asks who is most closely connected to the act for that transactional purpose. The real policy move appears in Article 7, paragraphs 3 and 4. Attribution is not denied merely because the outcome was unexpected. That is a broad attribution rule designed to protect transactional security. But attribution is not liability. Mistake, non-performance, and other remedial questions remain questions for other applicable law. Article 8 matters, but it is optional and supplemental. Its basic idea is that the user of the automated system generally bears the risk, while the counterparty may, in narrow circumstances, be denied reliance. So Article 8 is better understood as a safety valve than as the baseline structure of MLAC. The final point is what MLAC deliberately leaves open. It does not adopt a standalone rule for state of mind in automated contracting, even though many legal systems connect validity and remedies to some version of intention, knowledge, or good faith. It also does not replace consumer, financial, privacy, or AI governance law. That is why MLAC is best read as a framework for recognition and attribution, not as a complete theory of automated contracting. Thank you for watching.